The Dublin Regulation. The Dublin Regulation is a key part of the Common European Asylum System, CES. Its main purpose is to determine which EU member state is responsible for processing an individual's asylum application. The idea is that only one country should examine a person's application to avoid multiple claims. The most recent version is Dublin III, Regulation No. 604/2013, has been in effect since 2013. First point of entry rule. The Dublin system assigns responsibility to the first EU country an asylum seeker enters. This means that if someone crosses into the EU through Greece, for example, Greece is responsible for handling their asylum application, even if the person later moves to Germany or France. Family reunification clause. There are exceptions. If the asylum seeker has close family members, spouse, child, parent, legally staying in another member state, they may ask to be transferred there to apply for asylum. However, this requires proof and is often difficult to claim. Fingerprinting. Eurodac system, asylum seekers are fingerprinted, and their data is stored in the Eurodac database. This helps determine which country they first entered, and stops people from applying in multiple countries. Transfer between countries. If a person applies for asylum in a country that is not responsible under Dublin rules, that country can request to transfer the applicant to the correct country. If the responsible country accepts, the applicant will be moved there, sometimes against their will. There are strict time limits. For example, 6 months to transfer someone after a request is accepted. If these deadlines are missed, the responsibility may shift to the country where the person is currently located. The main goals of Dublin are to prevent multiple asylum applications in different countries, reduce delays and clarify responsibility, protect the efficiency and integrity of the EU asylum system. However, as discussed earlier, the system has faced heavy criticism for being unfair to border countries, ignoring asylum seekers' preferences, and causing humanitarian issues. The Dublin III regulation is one of the most criticised parts of the CS. It requires the first member state where an asylum seeker enters the EU to be responsible for examining the claim. This system disproportionately affects border countries like Greece, Italy, and Spain, placing a heavy administrative and humanitarian burden on them. It also disregards the asylum seeker's preferences, such as family ties or humanitarian needs, and can lead to repeated transfers, procedural delays, and rights violations. Furthermore, courts have repeatedly found that transfers under Dublin III to countries with systemic flaws in their asylum systems. For example, poor detention conditions or ineffective procedures breach EU and human rights law. The European Court of Human Rights, ECTHR, and the European Court of Justice, ECJ, have blocked such transfers in landmark cases, such as MSS versus Belgium and Greece. The MSS versus Belgium and Greece 2011 case is a landmark decision by the European Court of Human Rights. It involved an Afghan asylum seeker who was sent back to Greece by Belgium under the Dublin Regulation. The court found that the living conditions for asylum seekers in Greece were so poor, and the asylum system so ineffective, that sending him back violated his human rights, including the right not to be subjected to inhuman or degrading treatment. This case set an important standard for protecting asylum seekers in Europe.